Welcome back to our next GDPR compliance session. Please join me in welcoming Reemt Matthiesen. He's a partner at CMS and he advises German and international companies on all aspects of IT law with a focus on data protection and advising, amongst others, on international data transfers, such an important topic, especially nowadays, BCRs, model clauses, consent, etc., and the use of employee or customer data, such as data analysis and transfer. He will now enlighten us on a particularly interesting and relevant topic that has been the center of many discussions in the data protection community. So, DSARs and Article 15 of the GDPR, we already touched upon the topic a bit earlier, but we'll go deeper now. So he's giving us an update on recent developments, trends, and experiences, in particular regarding the copies of emails. So welcome, Mr. Matthiesen. I'm glad to have you here today. The floor is yours.
Thank you very much, and welcome to all of you on your screens at home or in your offices or wherever you are. As the introduction said, we're going to be handling the, I think, most relevant topic of access requests, in particular how to handle copies of emails and how to manage large amounts of data that are in scope of such an access request. We're going to be talking briefly about what I think is the correct scope of access rights, and then we're going to be talking extensively about exceptions and how to implement a strategy, how to deal with such access requests, what exceptions can apply, what exemptions can apply in light of current case law, as well as legal literature and guidance from authorities. So, as a starting point, here are two very typical examples that you see. An employee is making a fairly specified access request, specified but with an extreme large scope, copy of all data available about emails, and any document prepared in preparation of the termination of my employment contract and all emails. And then there's customers who say, give me a copy of all my personal data. So these access requests can cause severe headaches, especially if we're talking about employees that stayed a long time at a company, if we're talking about people in management positions that receive and send lots of emails and are included, or at least the names included in lots of documents like minutes. And for customers, if you think about someone who is a heavy buyer in an online shop and had lots of contacts with customer services and phone calls that were recorded, there's also the chance that you are talking about a very large data set. A very brief overview. The access right is a major principle of data protection law. It's also part of the Charter. This is important and we will come back to that. It's not just in the GDPR, it's also in the Charter. And the purpose is enable an individual to be aware of and verify the lawfulness. And it's a first step in order to enable an individual to exercise his rights. And that leads me to my first statement here, which is that you need to define the access right broadly, because there's a lot of discussion of to what extent can you limit this access right? Is it just an overview of personal data, just a summary, and all the kind of discussions that are out there? For example, when we talk about emails, why would you need to show a copy, and we come to the copy in a second, of an email that was sent by someone 5 years ago, if it's just an email talking about contractual terms or whatever. And the point is that if it's about enabling the individual to exercise his rights, for example, the right to deletion, that means he needs to be aware when those emails were sent and if they are still available to say, please delete those emails. So that's what makes this such a broad and large right. And when we talk about the copy, Article 15, subsection 3, a copy of personal data undergoing processing. It's also subject to debate. What does copy actually mean? Is it really just a summary of personal data, or is it actually a photocopy? And my understanding, and I don't like the results, but the legal argument that this is actually or needs to be understood as a photocopy, I think that's the most convincing argument. Especially if you look at recent ECJ or CGU, European Court of Justice case law. There is no case law about the photocopy, of course. But if you look at how the Court of Justice is interpreting data protection law and how he's making references to the Charter, and that this is such a fundamental right in these days, I would expect that the Court of Justice would say a copy is a photocopy, and that means a photocopy of every email that is out there. That would be probably a starting point, my expectation. And the language suggests that. We can discuss that later, but for now, please follow with me on this extensive understanding of what a copy actually means. Okay, so from an organizational standpoint, how do you handle a data subject access request? And there's a first point is you need to prepare. The same way you need to prepare for data breaches and all that kind of stuff. So you need to have a manual, a plan of attack, an SOP if you want to, that needs to specify where to look for data, depending on who's making the access request, where are the databases, who's responsible, and what time, how do we search systems manually or automatically. So there must be something in preparation, and this was also specifically mentioned by a judgment from the OLG Köln when it was discussing access of insurances. And this is also an important part, and this will be the main focus of the discussion or my presentation in the next minutes. And when we talk about the exception under 12 subsection 5 GDPR, when do we have an excessive request? In order to make that argument, I need to be able to show that I am diligently prepared to handle those requests in general. So as a second step, then, okay, I need to determine the scope of the access request, what is requested, very broad or specific data, and what is the quantity of data that we're talking about here. If it's a small quantity, and Recital 63 really just talks about quantity, not really about effort. If it's small quantity of data, then I need to provide access and need to provide a copy. And my next step then would be, and we'll come to that, what kind of exemptions are out there, in particular 29 BDSG, which is a German exemption, which allows you to not disclose personal data that is subject to secrecy obligations or that by nature should be secret. We'll come to that, as I said. And then 15.4 GDPR, where it's about trade secrets or third-party rights, trade secrets, and personal data of third individuals. So if it's a large quantity, my first question should be, is this so I have a large quantity of personal data about an employee, management position for 10 years at my company. Think about the bulk of email that you're talking about here. Did that person specify his request? And if the answer is no, or if he didn't specify it enough, so to say, that we're still dealing with a large quantity of data, then my next step in reviewing this is this an excessive request that allows me to reject or at least claim payment for digging out the data? And what you see here is a test or structure how to review if this is in fact an excessive request, and it relies heavily on the article I'm citing here in the CR 2020 from page 438. That, in my view, is one of the best articles out there at the moment, and I think it touches a lot of valid and important points of how to deal with the exception of 12 subsection 5 GDPR. First point is that excessive does not just mean that it's a repetitive request, because 12.5 says, in particular, a repetitive request can be excessive. So we've got other cases that would fall under the excessive exemption. And then we need to evaluate, okay, is this excessive? And the first one is the principle that this is an exception, so there's a high threshold. Again, we would need to have more than an above average effort to disclose all data that is requested. Again, Article 15 is a cornerstone of data protection, take that into account. And one particular point is, especially when you talk about customer data, did I comply with the principle of data limitation? So if I collect heavily click data, if I collect heavily data about purchases, transcripts of conversations with customer support, then it's a difficult argument to make, to say, oh, it's so much data, this is really excessive, because it was kind of your choice as a company to collect the data, so it's difficult to rely on the exception. On the other hand, especially for employee data, you may have a much better argument. So then, because the question is, and this is the key question, what kind of an effort is required? And I guess you're all aware of the decision by the Landgericht Heidelberg, where they said, we're talking about emails that are 9 years old, which would require an effort of more than 100,000 euros for reviewing all the emails if they contain any secrets or personal data of third parties. So that is a huge effort. And you need to be able to make that case as a company when you rely on that. You need to say, hey, look, we need to involve X and Y people. It's going to cost us this amount of money approximately. So that's why this is a huge effort. And I didn't use the term material effort here. It should be huge. But I mean, and when you do that review, what is huge? You're based that on the criteria for reviewing the data, because if you talk about, I don't know what, emails from 10 years that you're working at the company, someone would need to take a look and say what data of third persons in there that we should redact, and what trade secrets are in that data that we should redact. And again, the more effort you need to review that, and the more this is going to cost you, the easier to argue it's a huge effort. Of course, what you also need to take into account, to what extent can I use software that will extract or redact that data? And if you have software, you still can argue that, okay, yes, there's software which helps us redacting data, but there still needs to be a manual oversight, if the software worked appropriately. And after that, you need to do, as always, in data protection and constitutional law, a weighing of interests, proportionality. And then you need to take into account a few more things. How vulnerable is the subject? So say the small employee or the former manager. What kind of data are we talking about here? How sensitive is the data we're talking about probably? If you think about the case for the LG Heidelberg, where we're talking about business emails that were 9 years old, an extreme example. And then of course, on the other hand, you would have as another extreme example, the health data. And now we're in the middle, talking about travel expenses from an employee that are 3 years old, probably also not very sensitive. A third point is, what is the knowledge of data processing by the individual? I think that's a very, very good criteria. When I, as a former manager, would like to see the emails I sent out 5 years ago, I have an expectation what I'm going to see. Whereas as a customer, where I'm not really aware of what kind of profiling is taking place and how they manage my data and what they make of that data, how they score me, I have a much bigger incentive to see that data. And the last 2 points are both a bit about the abuse category. And abuse of rights is also a principle under EU law. And there's case law from the ECJ, which is cited in the article I indicated earlier. So if I make use of a right, but just for separate purposes, in order to cause pain, we all know the case that an employee is sacked and now he just throws in a data subject access request just to hurt a bit and provide an incentive to settle with the employer. And also in cases where we're still talking about, is this actually, was the termination justified? Is it valid or not? Are we suddenly creating a case of an e-discovery from the individual, which is outside of the principles of procedural law in Germany, at least? That by itself does not mean that you can reject the access request. You always need to be able to make the case that this is not about someone executing his rights in the way that recital 63 means, which is checking what data is being processed and if it's being processed in accordance with GDPR, but actually using this as a tool, as a vehicle to achieve another goal. And that's maybe a different case to make, and you cannot reject that outright by saying just the timing is suspicious. You need to provide further indications, and you need to probably also discuss with the individual. But if you can make a case here and document the decision, in some instances, and especially the painful ones, we're talking about former managers here that make an access request, you have a chance of at least pushing back without violating GDPR. Now, if that doesn't really fly, there are other exceptions that I would like to touch upon briefly here. You've got third-party rights, 15.4 GDPR. That is well established and heavily relied on. So you remove all trade secrets. What I tend to rely on in Germany is paragraph 29 BDSG, which is about professional secrecy. Not always helpful, but data that by its nature is secret. So this is a way to protect the whistleblower, and this is also the best solution in my eyes to reject an argument that you want to see the memos and the reports that were drafted before an employment contract was terminated. Because at least I've seen these cases, and I guess a lot of you have too. You ask for, can I please see the file that was prepared before the termination of my employment contract? And 29, I think is a good way to reject that claim, at least until the termination has been provided to the former employee, and probably also until after the case before labor court or civil court has been closed. Then we've got 33 BDSG, which is sometimes helpful if we talk about archive data. And as a final exception is you can always remove non-personal data to some extent. Even if it's not trade secrets, a lot of emails contain non-personal data. Think about a lot of emails where someone is just in CC, the individual making the access request is just in CC, and he receives false information minutes from a meeting where he didn't attend, or minutes where stuff was discussed that wasn't of his concern. All this could also be excluded. I'm aware that this is causing, again, this would create a major effort on behalf of the company to identify the data and remove it. But overall, I think, and this is my final take, in the future, we're going to see much more software and AI software that will review data and extract and redact data that is either subject to Section 15 GDPR, 29 GDPR, or is just non-personal data. And the same way that we see, and we talk about e-discovery cases and with the US, where data is heavily redacted and reviewed, and we use software to search data and redact data. This will be more and more used also in cases of data subject access requests under Article 15 GDPR. So in sum, I think so far 12 subsection 5 has been a bit overlooked and can be relied more upon, at least in major cases. And the second point is that software will play a much bigger role in redacting data under the exceptions that you see on the screen I'm sharing right now. And this is the last screen. So my presentation is over at this point, and I'm more than happy to take up any questions that you have or that may come up during the discussion. Thank you.
Thank you so much. I think the points you touched upon are of the utmost importance for basically every controller, because the broadness and the reach of Article 15 requests are still unanswered. Unfortunately, we don't really have time to forward you the questions we have in the chat. If you got time yourselves to stay on the platform for maybe a bit longer, I invite you, all the participants, the viewers from your home, from your offices, to reach out to Reemt directly. Because I guess there are further things to discuss. But at this point, thank you so much again. I'll definitely review your presentation again later on, because it was extremely fascinating, especially the points you made about misuse of the right. So thank you.
Development. Thank you. Thank you, everybody. Bye.